Hello, Jennifer and Sarah here from Elevate Transaction Services. Today we are going to discuss the recent updates made to numerous CAR forms and how they affect you and your clients. We are focusing only on the new and revised forms relating to the National Association of Realtors settlement changes.
Please remember the deadline to implement practices in relation to the NAR settlement is August 17th. We will also include a link to the forms release, quick summary, and FAQ on our website. And as always, this is not legal advice, and we strongly advise you to read through each form thoroughly and consult your broker.
There are two general disclosures that have been created and will be required going forward. The Broker Compensation Advisory, or BCA, is a new form being automatically included in both the RPA and RLA packages. It explains how brokers may be paid in a transaction, that the compensation is negotiable, and it also details the various methods of payment. Paragraph 1 discusses listings and seller compensation to both listing and selling brokers, and 1B details the potential benefits of offering buyers broker compensation. This is a great tool to use when discussing compensation with your seller. Paragraph 2 details buyer compensation to the broker and recommends a buyer representation agreement be in effect.
The other new required form is the Multiple Listing Service Addendum, or MLSA. This form replaces close to a page of text in the RLA. It explains what the MLS is, the benefits of using the MLS, and how public marketing works. The form also explains seller concessions and that the seller has the option to state seller concessions, if any, in the MLS.
Now let's discuss changes affecting listings. There are now multiple types of listing agreements, and we recommend you review each type. The Residential Listing Agreement, or RLA, exclusive authorization and right to sell, has been heavily revised, and a grid was created to resemble the newer RPA. Most of the information in the grid is not new. It was just reorganized to bundle all of the important information in one place. 2C outlines all commission scenarios available. Some agents include a flexible commission schedule and a separate modification of terms. This new section eliminates the need to do so. Keep in mind this only specifies listing broker commission.
Two new sections not related to commission were added to the grid. In section 2F1, the agent can list when they will present offers, if it is preferred to present all to the seller at once. In section 2F3, you can check any reports that will be ordered by the seller during the listing period. In section 2J, the seller can opt out of a lockbox and/or for sale signage. Section 4 outlines the new compensation rules resulting from the NAR settlement. This is an important section to read through thoroughly. Section 9 is new and explains dual agency and non-represented buyers. The seller acknowledges that the buyer may enter into a representation agreement with a potential buyer, thereby creating dual agency. The seller acknowledges that the buyer is unrepresented. It will be documented on a buyer non-agency form, or BNA.
There's also the Residential Listing Agreement Non-Exclusive Authorization and Right to Sell, OPEN, or RLAN. With this listing agreement, a seller can sign contracts with as many listing agents as they want. Please also note that the Vacant Land Agreement, or VLL, Commercial and Residential Income Listing Agreement, or CLA, and Business Listing Agreement, or BLA, were created and/or updated to mimic the changes to the RLA.
Now let's go over the disclosure and modification to the listing agreement, DMLA. This is a new form used to modify listing agreements signed prior to June 2024. It discloses to the seller that offering compensation through the MLS will be prohibited once the settlement is implemented. This should be used for all current listing agreements signed on the outdated RLA. This is a form you will want to send now to your sellers to sign. Again, the deadline for this is August 17th.
Next, let's discuss the new and updated forms for working with buyers. First, we'll go over the Seller Payment to Buyer's Broker, or SPBB. This revised form is simplified and specifies the amount that the buyer is requesting the seller pay to the buyer's broker in Section 1B. Section 2B limits the amount, and the remainder of the form acts as a disclosure around buyer compensation and delivery, and that there shall be no excess compensation owed under the BRBC if the agent represents both the buyer and seller. This form is recommended to be filled out in conjunction with your offer.
Next is the Buyer Representation and Broker Compensation Agreement, BRBC. This form was heavily revised with the same purpose. However, the buyer can now opt for exclusive or a non-exclusive representation. Section 2A details the representation period with a maximum of 3 months, unless the buyer is a corporation, LLC, or partnership, and the type of representation. If you want exclusive representation, check the box in 2A2. Section 2B details the type of property to be acquired. You have the option of checking 2C and including a buyer preferences and priorities form, BIP.
Section 2D details broker compensation with the specification that the broker shall not receive any amount in excess of 2D1 unless modified in a subsequent BRBC. Section 2F allows for a buyer financial information form, or BFPI, to be included to determine if the buyer's loan doesn't allow a buyer payment to broker or if they do not have the funds. 9B lists the consequences and specifies that if the buyer doesn't have the funds to pay the broker and the seller, or the listing broker is not offering the buyer broker compensation for the property, the buyer's broker can terminate the representation agreement.
Next up is the disclosure and modification to buyer representation agreement, or the DMBR. This is a disclosure to inform your current buyers of a nationwide settlement agreement, specifically that the MLS will no longer be used to determine compensation to buyers brokers. You'll need to get this form signed for the existing buyer representation agreements you have that were signed before June 2024. Again, the deadline is August 17th.
Let's touch briefly on the modification of terms buyer representation agreement, or MTBR. This is a new form used to modify the buyer representation agreement. Another new form is the Open House Visitor Non-Agency Disclosure and Sign-In, or OHNA. This is a new form for agents holding open houses. It may be used if NAR will require open house viewers to sign a BRBC. This document informs viewers that they are not in any agency relationship with the agent holding the open house. The form is technically preemptive as the process is unknown at this time.
Another new form is the Property Showing and Representation Agreement, or PSRA. This creates a written non-exclusive representation agreement with the buyer and is valid for up to 3 properties or open houses, and the maximum representation period is 30 days.
A new form is the Notice to Broker of Involved Parties, or NBIP, that establishes that a buyer's broker has been involved in a party that the buyer is purchasing, which triggers a right to be compensated. The address of the involved property will be inputted in Section 4. A quick note that the following forms have been removed: Cooperating Broker Compensation Agreement, or CBC, and the Anticipated Broker Compensation Disclosure, or ABCD. Other various forms have been updated to remove any verbiage relating to cooperating broker compensation.
The following recommendation is directly from CAR. When working with a buyer to comply with NAR Settlement, a buyer's broker must enter into a written agreement with the buyer before the buyer tours any homes with the broker or an affiliated agent. That agreement must disclose the specific amount or rate of compensation the broker will receive, or specify how the amount will be determined. The buyer's broker cannot receive compensation for brokerage services from any source that exceeds the amount or rate in the agreement with the buyer. It is the agent's responsibility to ensure that the buyer understands that they will be responsible to pay their broker.
A buyer may pay their broker's compensation from any source. This could come from the buyer's liquid funds, or the buyer could find a third party to pay their broker. For example, a buyer could seek to use programs that assist buyers with closing costs or seek concessions from the seller through the purchase agreement. Concessions or other assistance can be used for closing costs, including payments to the buyer's broker. Buyers can also ask their broker to seek payment directly from the seller by using the SPBB. In the future, a buyer's loan to purchase a property may permit loan proceeds to be used to compensate the buyer's broker, but currently most lenders will not permit this use for loan proceeds.
We know that this is a lot of information, and we recommend consulting with your broker or CAR on formal training available for these changes. As a reminder, we have posted the link to the CAR Update Quick Summary and FAQ on our website. We hope you found this video helpful. If you have any follow-up questions, we are happy to answer them for you. Please reach out to us. All of our contact information is on our website at elevatetransactionservices.com.
Thank you.